Good morning, everyone. Welcome to the second installment of Fasken's Estate Litigation webinar series. Previously, Karen Wyke, Eric Clavier, and Jonathan Charon gave a very informative presentation on charitable gifts, common litigation traps associated with charitable gifting, and on strategies or best practices to avoid those type of issues before they occurred. If you weren't able to tune into that previous webinar, or if that topic sounds like something you'd be interested in hearing more about, we will be circulating the details of that webinar following this presentation. Those materials are also available on our website through the Fasken portal, which you could access that way. My name is Desmond Mitic. I'm a litigation and dispute resolution associate in Fasken Calgary's office, and I'll be facilitating our panel's discussion this morning. The format of today's webinar will be that of an interview between myself as moderator and our panelists, where I'll be posing your questions to the panelists who will respond in real time. Joining me this morning are three of Fasken's prominent estate litigation practitioners who will be sharing with me and you some of their experience, their insight, and their expertise as it relates to estate litigation issues concerning powers of attorney. From Quebec, we're joined by Yoni Feingold. Yoni is a partner in the Litigation and Dispute Resolution Group in Fasken's Montreal office, where he routinely resolves disputes regarding wills, trusts, and estates, in addition to his general commercial litigation practice. From British Columbia, we're joined by Elise Kohno. Elise is an associate in the Litigation and Dispute Resolution Group in Fasken's Vancouver office, where she specializes in trusts, wills, estates, and charities litigations. Elise works closely with Helen Lowe, the leader of Fasken's estate litigation subgroup and co-leader of Fasken's litigation and dispute resolution group nationally. Unfortunately, and due to an unforeseen emergency, Helen won't be able to join us for the conversation this morning. So instead, we bring you Eric Clavier, a trust and estate litigation lawyer with nearly 20 years of litigation experience, including abuse of power of attorney claims, wills and trust disputes, undue influence and incapacity claims, committeeship applications, and breach of fiduciary duty claims. Welcome, everyone. And so over the next hour, Yoni, Elise, Eric, and I will be discussing and answering your questions regarding a very common legal instrument and estate planning tool, the power of attorney, or as they call it in Quebec, the protection mandate. For everyone watching who submitted questions to our panelists in advance of the webinar, thank you. I've reviewed those submissions, and I plan on posing them to our panel throughout the course of the discussion this morning. For those of you who have not submitted questions in advance, but who may have questions as the discussion amongst the panelists unfolds, I encourage you to drop them into the chat feature in real time. We will endeavor to address all of your questions through the presentation or by way of follow-up, if necessary. And with those introductory remarks out of the way, let's turn to our panelists for a moment. Elise, how are you this morning?
I'm great. Thank you, Desmond.
Can you let the audience know a little bit about your practice and give us some context about how you find yourself coming into disputes as they relate to powers of attorney?
So as Desmond mentioned, I practice in the area of estate, wills, and trust litigation, and I work primarily with Helen Lowe, who can't be with us today. Estate litigation often arises where an individual has died and parties are fighting over that individual's estate. So for example, a parent has passed away and the children of that parent are fighting about who gets what under the will. But estate litigation can also involve matters that arise before a person has died. And one area of that would be litigation against an attorney or a power of attorney. The power of attorney is an agency relationship between one adult, who we often refer to as the donor, who authorizes one or more adults, or sometimes a trust company, to act as that adult's agent, who is also known as the attorney. for some or all of the adult's legal, property, and financial matters. This authority may also endure the adult's subsequent mental incapacity. A really basic example of where the power of attorney can lead to litigation is in a family setting where there are multiple siblings and one sibling is acting as the attorney for the parent. Say, for example, another sibling has suspicions about how the attorney sibling is acting. Generally, the type of litigation that arises usually surrounds what the attorney is doing and whether or not the attorney is acting in a way that is benefiting themselves or furthering their own interest. In British Columbia, powers of attorney are governed by legislation, the Power of Attorney Act. And some other provinces also have similar legislation, which we will get into more throughout the presentation today.
Thank you, Elise, for that introduction and context. Yoni, let's hear from you. Can you give us a brief introduction to your practice and some appreciation on how issues related to protection mandates occupy your time?
Sure. First of all, thank you, Desmond, for that introduction, and thank you, Elise, for your introductory remarks as well. So, Desmond, as you had mentioned, I'm a partner at the Montreal office. I specialize in trust and estate litigation, and as Elise had mentioned before, there are numerous litigious issues that also concern powers of attorney that I think fall within the umbrella of trust and estate litigation, and a number of issues that I deal with on a regular basis. As you also mentioned, in Quebec, we refer to these powers of attorney as protection mandates. Quebec is the central statute governing them is the Civil Code of Quebec. It's a civil system in our province. And at the outset, I should mention that there are going to be some very important amendments that will be brought and coming into force and effect in the summer of 2022 through what is referred to as Bill 18. The purpose of Bill 18, generally speaking, was to bring our current regime in line with international norms and standards on how to deal with individuals suffering from a variety of different disabilities, including incapacity. So, and additionally, by the way, intended really to add a number of safeguards and against exploitation and abuse. So, as in the common law jurisdictions, a protection mandate or a power of attorney is a private instrument that is prepared by the donor, or as we refer to them in Quebec, the mandator, granting certain decision-making authority to one or more attorneys, as we refer to them in Quebec, mandataries. And those that authority can really be split into two broad categories. So there will be the mandate to the person and the mandate to the property. The person deals with issues such as care, and we'll get into those details, I'm sure, later on during this conference. And property, as its name suggests, concerns the individual's assets. And given that it is a private act, the mandator is at liberty to really identify the full scope of the powers that his mandatory or mandataries have with respect to those two broad categories. In Quebec, the power of attorney or the mandate can take two forms in its preparation. It can be prepared by a notarial act. It can also be prepared by written instrument before two witnesses. And if the mandate that has been prepared is either incomplete or insufficient, insufficiently defines the powers that are attributed to the mandate, then a court can supplement it with a by imposing protective supervision, which falls under the public regime. But as we'll discuss, and as I'll point out, I'm sure throughout the conference, our recommendation is always to be as comprehensive as possible when preparing your mandate, so that you don't have the court intervening frequently, you don't have other interested parties raising questions and doubting whether the mandatory or mandataries actually have the authorization to do what they claim that they have the authority to do. Thank you.
Thank you, Yoni. And I see we have some questions rolling in already regarding the scope of the power of the attorney and, what the attorney is authorized or not authorized to do. But before we get there, let's turn to Eric for a moment. Welcome, Eric.
Thank you, Desmond. Thank you, Elise, and thank you, Yoni.
Eric, you've certainly been doing this for a long time, so just want to hear a few words from you about how you find yourself encountering powers of attorney and issues regarding power of attorney in your practice.
Sure, and I think that at the onset, it's important to remember that a power of attorney is an extremely useful and necessary planning tool if you're elderly or if there's risk that you might lose capacity, because it enables somebody, if it's an enduring power of attorney, to essentially manage your finances on your behalf without the need for an application for committeeship, as we call it in British Columbia, which is akin to guardianship in other provinces. And so it's an important tool, but it's also a tool that has a lot of importance. It has a lot of responsibility for the person who is assuming the role, because they act, in the case of an incapable adult, in a fiduciary capacity. And with that comes all the risk of litigation and disputes amongst other family members who may think that that particular fiduciary, that attorney, is not doing what they should be doing or is not acting in the best interests of the adult, and often leads to disputes between family members, as Elise mentioned. But I think that one has to remember that with the aging population in Canada, the power of attorney is an extremely useful tool. And despite the risks of litigation, it is certainly a much cheaper way for an adult to regulate who will look after their affairs in the event of them losing capacity. I should just also say that the power of attorney can, of course, be a mere agency agreement for as long as the adult has capacity and is therefore able to revoke that agency agreement at any time. But as soon as it transitions into an enduring power of attorney where the adult has lost capacity, that's where the adult can no longer take steps to revoke it or to ask for an accounting from the attorney. And that's really where the disputes between family members, where the disputes in litigation arise. So overall, I find that a lot of issues are where one person thinks that their brother or their sister, who is dad or mom's attorney, is abusing funds, is essentially dissipating assets or not acting properly, and that results in litigation. And there's lots of it, unfortunately.
Thank you, Eric, for that helpful context. Now that we've met the panel, why don't we move towards answering some of the questions that are coming in from the audience. But before we get there, I just want to make a few brief comments regarding the nomenclature we're going to be using, some of which you've already heard from our panelists this morning, but just so everybody's on the same page as we go forward. Here in the common law provinces, we refer to the power of attorney as a legal power, and that power is granted by a person that we generally call the donor of the power. And the person receiving the power, who is authorized to act on behalf of the donor, is called the donee. Sometimes we call them the attorney under a power of attorney. And in Quebec, those terms aren't really used. They're calling this person the mandator, the person granting the power, and the mandatary, the person receiving the power and authorized to act. So I just wanted to keep those terms at the forefront of everybody's mind as we get into it. Justin, if you could take us to slide 6, please. First thing I want to talk about is the scope of the power granted by the power of attorney instrument. Yoni's already alluded to this a little bit, but I want to go to you first, Elise. As Eric has mentioned, these documents are so common and so valuable as estate planning tools. In your experience, are the powers granted pretty standard form, or do they tend to be unique as between instruments?
So powers of attorney are private contractual documents between the donor and the attorney. So therefore, the scope granted by a power of attorney document really depends on the powers the donor wants to give and the individual document itself. The scope of potential donor-imposed restrictions is, as a result, essentially limitless, but is always governed by the power of attorney legislation that exists in the province that the document is being made. A donor can limit his or her attorney's powers by, for example, restricting the property subject to the power, restricting the purpose of the power, restricting the time during which the power might be used, the geography, etc. When dealing with a general, not an enduring power of attorney, donors should be encouraged to place any restrictions directly in the power of attorney document to avoid any confusion. The greatest restriction on an attorney's powers, which Eric has already alluded to today, is likely their fiduciary duties. The attorney may not exercise the power of attorney for their own personal benefit unless expressly authorized to do so by the document itself, or unless the attorney is acting within the full knowledge and consent of his or her donor. He or she must also not allow personal interests to conflict with the power of attorney role, and must not use the donor's assets for the donor's benefit, and must not commingle assets. At all times, the attorney has to act honestly and in good faith and in the donor's best interest. The attorney also has to exercise the care and skill that a reasonably prudent person with the attorney's experience and expertise would exercise. And that being said, there's also prohibitions or certain things that an attorney cannot do in that role. For an example, an attorney cannot make or revoke a will, and attorneys also cannot swear affidavits or make any executive decisions that their donor would make that would affect or impact or change a donor's estate plan. For example, when a donor of a power of attorney becomes incapable, it is often the case that the power of attorney will receive the donor's estate planning documents. In that case, the attorney cannot act in any way that would be contrary to the donor's estate planning documents. And an example of that would be, say, for example, if under somebody's will, the donor has given a gift of their car to somebody, the attorney cannot then go and sell that person's car, because that would be contrary to the power of attorney document and to the general estate plan. So therefore, the takeaway is that it's really important when you are making a power of attorney document, or if you are acting as an attorney for somebody else, that it's considered in the entirety of that person's estate plan.
Thanks, Elise, for giving us that information. It seems like the power of attorney is an obligation of significant responsibility. And like you mentioned, in many cases, it can be that of a fiduciary responsibility, the most onerous of the responsibilities recognized at law. Eric, I just want to bring this back to you. You mentioned in your introduction how some attorneys are obligated to act as fiduciaries with respect to the donors, but some aren't. Could you give us a bit more context about when the fiduciary relationship arises under a power of attorney and when a different sort of relationship exists?
Sure. So just generally speaking, a power of attorney enables somebody else to act on your behalf within the confines and limits of what you're authorizing them to do. If you're a fully capable adult and you're authorizing someone to act on your behalf, then they are your agent until such time as you lose capacity, because at that stage, the relationship changes into a fiduciary role because there's nobody to hold that person to account. So now they're acting essentially akin to a trustee. They have the same obligations of good faith and the same fiduciary duties that they owe to me as the adult. Inherent in that, for example, is my inability to revoke the power of attorney or the agency essentially agreement that I gave this person once I lose capacity. It transitions from being a contractual relationship where I could at any time cancel the power of attorney to being one where this person is now representing me and has to act in my best interests because there is no ability for me to revoke the power of attorney anymore.
Right. And that's interesting. I would imagine that more litigation issues typically crop up once that person has crossed the line of the loss of capacity. So Yoni, let's hear from you for a minute. Do Eric and Elise's observations with respect to powers granted under these instruments hold true in Quebec, or are there different forces, different provisions of the civil code at play that one needs to be aware of?
Well, the big picture is that it is similar across the board, but as you said, because it is a codified system, some of the provisions may be very, very specific. So as I had previously mentioned, there are really two broad categories of authority or power that will be conferred upon the mandatory one or more. So the first one that I had alluded to is the mandate to the person, and those decisions really concern issues of a very personal nature, such as, for instance, the type of care that the mandator is to receive or even not to receive. So all those questions of consent to care can be conferred upon the mandatory. And in fact, in the absence of anything specific within the mandate, it is the mandatory who makes those decisions in virtue of the law. That being said, the mandator is welcome and even encouraged, if they have specific wishes about the types of care that they wish to receive or not receive, such as in advanced medical directives, to stipulate that either in the mandate or in a document that we call the advanced medical directives. Another area within the mandate to the person that the mandatory controls is or participates in is where the mandator is going to live. So we can imagine that the mandator is receiving the care that they require while still remaining in their residence. But at a certain point, it just becomes too difficult to provide them with the care that they need, and they have to be placed in a seniors residence or in some other facility with, nursing capabilities. So that the decision of when to make the move and the transition and where will fall upon the mandatory or mandataries. And of course, one of the basic obligations with respect to the mandate to the person is to ensure that the basic personal needs are met. Now, with respect to property, that can be further divided into two categories, which we refer to in Quebec as simple administration or full administration. So that really distinguishes the scope of the power over the property that the mandatory can exercise. Simple administration, as the name suggests, is quite basic. It's conservatory in nature. The mandatory is permitted to collect the fruits and the revenues generated by the assets. They can continue to use the assets the way that they have been used without changing their destination. So you can imagine that the mandator may have owned an income generating property, and it was, let's say, it was an apartment. The mandatory can continue to operate it as though they were landlord and collect the rents, but they cannot change the destination and turn it into a commercial property, apply for rezoning and put a store in there. Given that it is so limited, we do not recommend using or conferring powers of mere simple administration on your mandatory, because what will inevitably happen is that mandatory will have to turn to the court to apply for authorization to take certain steps that will be necessary to get money, for instance, selling assets, to liquidate some of these assets so that they have the money to do what is necessary to care for the mandator. And of course, the court, in reviewing the mandate, may determine that there simply aren't enough powers given to the mandatory rather, that the best alternative is to impose protective supervision, which is, as I had mentioned before, under the public regime, and that defeats the purpose of having this private instrument. By contrast to simple administration is full administration, and that is essentially where the mandatory can exercise the full spectrum of the right of property and of ownership. So that mandatory can sell property, can charge it with the lien, can put it up as collateral, and can even, as I had mentioned, change its destination. One caveat with respect to that, and it's something that Elise had mentioned, applies in the common law jurisdictions as well. The mandatory cannot himself be a party to any of the contracts, cannot put himself in a position of conflict of interest, but can also not be a party to a contract involving the mandator's assets. So, for instance, one can imagine a scenario where the mandatory is the spouse of the person who's lost capacity. The spouse owns 50% of their place of residence, and it is now time to sell the house. She needs to liquidate the asset either for money or for whatever other reason. Unless it is specifically provided for in the mandate, that mandatory cannot participate in that transaction and will have to apply for authorization from the court. So, as I had mentioned before, this private act can do a lot for the mandator, so long as it is clearly and broadly provided for within the document itself. And so our recommendation is always to really consider, how far do you want your mandatory to go? How do we avoid some of the roadblocks in his or her way, and draft accordingly?
Desmond, if I can just weigh in very briefly, we haven't mentioned the mandate of the person equivalent within the context of British Columbia. And the reason for that is what we would call a representation agreement, which is an entirely different act. And so it's important to remember across provinces, there are different rules and regulations that govern powers of attorney and whether or not those powers of attorney include the ability to make personal healthcare decisions for the adult granting that instrument. But at least in British Columbia, those are separate documents. And I just thought I'd raise that because otherwise it would perhaps not make sense why in Quebec, the document authorizes you to make personal decisions, but in British Columbia, the discussion does not focus on that.
Thank you for that helpful clarification, Eric. And thank you, Yoni, for all the information that you provided. I think we have some interesting questions rolling in. With respect to the points you were just making, Yoni, about how the power granted under the protection mandate is a balancing act. You want to work as hard as you can to articulate all the powers you want the mandatory to have from the inception of the creation of the document, but in many cases, maybe there are things that the mandatory needs to do or should do that they're not necessarily authorized to do. You mentioned potential recourse to the court. We have one of our viewers asking, can a power of attorney sell assets of the donor if the money is needed to care for the donor and preserve their lifestyle and dignity, though they may not be specifically authorized to do that under the instrument itself?
So I suppose the question means if the mandatory has mere simple administration, and they're supposed to be conserving the property, that is something that you would have to apply to the court for a special authorization, and you'd have to demonstrate the need. But the courts are very sensitive to that reality. And I would expect that in the absence of any contestation from any other interested parties, such as other family members or a replacement mandatory, et cetera, that the court would authorize that. Now, if it appears that it is really contradictory with the overall terms of the mandate, then the court might decide, this mandate is simply insufficient. We're going to impose a different regime of protective supervision in the circumstances.
Interesting. So there is recourse for the mandatory or the attorney to seek the court's direction when they want to make actions that are, in their mind, in the best interests of the donor, but they're not specifically authorized to do that under the instrument itself.
Correct. And the courts will always be guided by the principle of the best interest of the donor.
What about in the common law jurisdictions, Eric? Do attorneys have latitude to seek direction from the court when they want to do something they may not be specifically authorized to do under the instrument itself?
I'll give you an example. If an attorney, for example, wants to change the RIF or the TFSA or the RSP that the adult has put in place, and there's no specific authority in the POA that says that this is something that they can do, then the Act actually in British Columbia at least provides some options. And one of the things that the attorney could do is apply to a court to change a designation of a beneficiary by the court. So the court would authorize that change, but the court would have to be presented with compelling reasons as to why that is necessary. But the Act also provides that you can, for example, change a TFSA. You can change an RSP to a different institution, provided that when you're renewing or you're replacing or converting a similar instrument, you are appointing the same designated beneficiaries, right? So that is something that is determined in terms of the Act. And if you want to change the designation of the beneficiaries, and you are creating a new policy, or you're changing the policy to a different institution, and you wanted to change a designated beneficiary to someone who is not named in the prior policy, the only option that you would have without court intervention is to then designate the adult's estate. So you can only really follow the adult's initial designations, or you would nominate the adult's estate as the designee, or you would have to approach the court for directions and authority to make a change. But that's just one example how in British Columbia, at least, even if there are no specific powers outlined with regards to the designation of beneficiaries, you are able to approach the court if necessary, and the Act does provide suitable alternatives if you don't want to go the court route.
That's great insight, Eric, and I think a great example. I want to talk a little bit now about the power of the attorney to gift or to donate to charity. We have one of our viewers asking, does Ontario law still set a limit on how much of the donor's property can be gifted for charitable purposes? And I know the answer to that question to be yes. Ontario statute still limits the ability of the attorney to gift the donor's property. Specifically, the rule is codified in Section 37, Sub 4 of the Substitute Decisions Act, which provides that under a continuing power of attorney, that is one that continues after the person has become incapacitated, the total value of charitable gifts cannot exceed 20% of the income of the property in the year in which the gift is made, and the maximum amount allowable pursuant to the instrument. So there is a balancing act there in the legislation between what the instrument itself provides for and another maximum amount as defined by 20% of the income from that property in that year. So that's the case in Ontario. Eric, do you know if that holds true in British Columbia and other common law jurisdictions?
Well, so I can only really speak for British Columbia, but I will say this, is that you must remember that fundamentally, when you're issuing a power of attorney, you have the ability to describe the rights and powers that you're giving to your attorney. So provided you have capacity, and you wouldn't be able to conclude or to execute a power of attorney if you don't, you can delineate what powers you're giving your attorney. So if you want your attorney to be able to make gifts indiscriminately and in the exercise of his or her discretion, then you could stipulate for that specifically. You could say they can make gifts up to $50,000 if you wanted to limit them to that, or you could specifically say that you are limiting them, or you're saying they're not having an ability to make gifts at all. But in the absence of clear language to that effect, in British Columbia, the Act provides maximum gift provisions, and they're different from Ontario's. So it's important to remember that every province is distinct. In British Columbia, if there's nothing specific in the power of attorney that authorizes the attorney to make gifts, then the maximum is the lesser of $5,000 or 10% of the adult's taxable income for the previous year. And that is per year. So you could be making the maximum of 5,000 or 10% of the adult's taxable income for the previous year as a gift every year, but you would not be able to exceed that unless the power of attorney specifically says you can, and to what extent.
Thanks, Eric. And just before I give you a break here, I have another question that just rolled in. It really pertains to something you had mentioned before about the distinction between a power of attorney for someone's property and an authorization to make decisions about their health and their health care. We have a viewer asking, what about a power of attorney for personal care? Is that an instrument you're familiar with, or does it go by another name that maybe this person's thinking of?
I believe that in Ontario, and I don't practice there, so don't quote me on it, but I believe that in Ontario, that would be the equivalent of a British Columbian representation agreement. Essentially, it is the authority to make those personal healthcare decisions that I spoke about earlier, or that Yoni mentioned in his mandate to the person. It is really an ability under that instrument. I would imagine in Ontario, it would echo what we have in the representation agreement in British Columbia to make the kind of healthcare decisions that a person can no longer make once they've lost capacity, such as where they should live, should they be placed in a full-time care facility, should they be moved from one city to another, whatever is in their best interests. But yes, I would suggest that that name, the power of attorney in British Columbia, is limited to financial affairs. The representation agreement is with respect to personal healthcare decisions, although in British Columbia, at least, it can also authorize you to make some routine financial decisions. But when we're talking about the British Columbia POA, it's limited only to financial decisions. And in other provinces, you might have a power of attorney that relates to personal healthcare decisions. But we're talking about the equivalent of a representation agreement in BC. And so it's important. When I spoke earlier on about how important the power of attorney is, a representation agreement is part of your estate planning, which would generally consist of making your last will and testament, making a power of attorney that governs your financial affairs, and making a personal healthcare representation agreement that would govern your healthcare decision-making.
Great, thank you for that comprehensive answer. I just want to move on now to the next topic of conversation, which is who can be the attorney? Now, maybe I can go to you, Elise. You can give us a little bit of insight on who can become somebody's attorney under a power of attorney. Is this something that you could appoint to anyone, or are there any restrictions?
So as I had alluded to earlier, that power of attorney document is very much so a private agreement between the donor and the attorney. So quite generally, the donor has a lot of flexibility as to who they want to appoint as his or her attorney. That being said, really any capable person who's of the age of majority can act as the power of attorney. It's really important when making this decision that it's really based upon someone that you trust. So you want to be aware of, as we've already alluded to, that power of attorney documents can lead to various types of litigation and various requirements to go to court and perhaps getting court orders. So this makes it even more imperative that when you're selecting your attorney, it's somebody that you really trust that can act in a way that's dealing with your financial and legal matters. And that being said, there's also certain prohibitions on who you cannot appoint as an attorney, which I'll get to in a bit. But for example, you can't appoint in British Columbia, you can't appoint the public guardian and trustee as your attorney. And you also cannot appoint somebody who is working at a healthcare facility where the donor is receiving treatment. So those are just some examples that are governed in the legislation in British Columbia of who you cannot appoint as an attorney. But generally, it should really come down to who you trust, and you have a lot of flexibility within that.
Thanks, Elise. It's clear that selecting your attorney is a big decision and one that should not be taken lightly. Yoni, let me ask you this. Often, as Eric was mentioning, the power of attorney is a very important estate planning document, often one piece of a larger estate plan, which would include maybe some medical directives and which would include this person's will, presumably. Are there any considerations to be made before appointing someone in both roles as, say, executor of your will and as power of attorney under a protection mandate?
Well, I would say that apart from this being someone whom you trust implicitly, which is most often a close relative, the main issue and thing to consider is the accounting that comes at the end of the termination of the mandate. So the termination of the mandate can come about, and most often does come about as a function of the death of the mandator, and it's at that point where the mandatory will have an obligation to render account. So to whom will that mandatory render account if he is also the executor of the estate? So it could potentially lead to conflict. Will the liquidator ask himself or impose upon himself the obligation to render an account? Will he, go easy? I mean, it's a natural place for disputes to arise when the rest of the family who has not either been involved in caring for their parent or relative who's been aging, but then has an interest in the estate to occur.
That's interesting. Thanks, Yoni. It definitely does seem like an area where mischief could potentially occur that our viewers should be aware of, and that might want to be something that they watch out for in considering their own estate plans or estate plans for their clients. While we're on this point, I think it feeds nicely into this question I just received. And Eric, maybe I'll pose this to you. Suppose something does go wrong. Suppose someone is alleging that their brother or sister has been abusing their power of attorney or acting outside the scope of its authority. We have a viewer asking, is there a limitation period on when these kind of disputes can be brought before the court, or is this more like a criminal matter where a limitation period after someone becomes aware of some sort of mischief going on that they wouldn't or would be able to lodge a legal action?
Well, the answer would take up most of the rest of this session. So I'm going to try and be concise and just say broadly what you can do. I mean, if you have concerns about, let's say, your brother who is dad's power of attorney and abusing that power of attorney, then your real obligation as the child of that parent is to try and take steps right away. In BC, you could make a complaint, or you could approach the public guardian and trustee to investigate any form of abuse. You could also apply for what we call a committeeship, or as I've mentioned earlier on, a guardianship in other province, which automatically, if the court grants you committeeship, it would automatically terminate any existing power of attorney, and it would therefore end that person's mandate to cause mischief. Moreover, it would entitle the committee or the guardian to call for that former attorney to provide an accounting, to have access to all financial records, to have access to that adult's finances, essentially, to determine whether or not there has been misappropriation of funds, and then to act in order to claw those back. Alternatively, it would be up to the executor after the death of the adult to investigate whether or not there has been abuse by the attorney during the period of their attorneyship, and then to determine whether or not claims are available to claw back assets that have been misappropriated. But I think that the big issue is that if you suspect there is mischief afoot, then it is to act soon. There was a terrible case out of Ontario a couple of years ago that I remember reading in the paper, where a millionaire father had given his daughter and son power of attorney, and they then proceeded to deplete the funds out of his bank account to the extent that he had no money to go into a care home anymore at a time when he needed it and didn't have capacity. And so if there'd been somebody concerned in that case who had raised issues and alarms earlier on and been in a position to stop that from happening, it would have left the adult in a far better position than ultimately happened in that case. So strike first and strike hard in the event that you see that something is going on that you think is suspicious, because the adult, in the event of incapacity, is unable to do it themselves.
Thank you, Eric. And that is an interesting point, and I think great advice. So I think this leads nicely into another common scenario that we often see. Instead of just one power of attorney being appointed or one attorney, we often see situations where maybe two people are appointed under one instrument, or two instruments are granting two people different powers. So maybe, Elise, I'll take this question to you. Where more than one person is granted a power of attorney with respect to a single donor, are the two attorneys obligated to work together? Can they act independently, or is the division of power somewhere in the middle?
So in British Columbia, the proper interpretation of the Power of Attorney Act is that if you appoint more than one person, you have to specify the scope of the powers that each attorney that you have appointed has. So if the power of attorney document grants the same powers to more than one attorney, the attorneys must act unanimously in exercising that authority. That being said, that is unless the document itself describes circumstances where the attorneys do not need to act unanimously, or the document sets out how conflict between the attorneys can be resolved, or the document authorizes an attorney to act as an alternate attorney and sets out circumstances in which the alternate attorney is authorized to act in place of the primary attorney. This can often lead to litigation. So, for example, what happens if one attorney is unable or unwilling to act? So that being said, practically, this isn't necessarily recommended. And you can get around this problem by creating two separate power of attorney documents, appointing two separate attorneys. However, in that case, you would also, again, have to trust that those attorneys could act together and in a way that wouldn't be in conflict with one another.
Thanks, Elise. So it certainly seems like there is some latitude to appoint more than one person and some considerations that need to be made when doing so. Yoni, why don't we hear from you? What are the advantages or maybe disadvantages in your perspective of granting more than one power of attorney or a joint power?
So first of all, let me just state that the rules in Quebec are very similar to those that Elise just set out. So a mandator may appoint one or more mandatory to both to his person and to the property. When it's to the person, by the way, it actually has to be a natural person and not a company, whereas a trust company or a professional can be applied to, appointed to administer property. So, and similarly, the general rule is that if it's not otherwise stipulated in the mandate, the mandataries have to act in concert. And that can obviously lead or naturally lead to discord and to impasses, which will then have to be resolved in court. So we always recommend that if the mandator would like to name more than one mandatory to act at a time, then they should provide for dispute resolution mechanisms, such as they decide, it's three, they decide by majority. So that they don't find themselves in an impasse. I would also add that we recommend always naming the mode for replacing your mandatory. So either you identify subsequent replacement mandatories, or you stipulate that a resigning mandatory can name his replacement, or the two remaining ones can name a third, because if a mandator finds themselves in a situation where they're out of capable mandatories, the court will intervene and at that point impose protective supervision.
Desmond, before we go on, you have to ask yourself why you would want to have two attorneys making decisions with respect to the same transaction. And oftentimes a client will come to us and say, well, I want to make sure that they keep checks and balances on each other. That's a silly argument, because that means you have some suspicions that one or other isn't going to be acting properly. And so our advice would always be, well, then don't go with these people, because clearly you don't trust them enough to act in your best interests on their own. Another argument one does hear is that, well, I don't want to offend my daughter by appointing my son as the attorney. But as we've heard, it can result in deadlock. And that deadlock, unless there's a dispute mechanism in the actual instrument, will result in court proceedings. Court proceedings are lengthy, they're expensive, and you think that your daughter and son won't get along if you appoint one as the attorney and not the other. Try them again after they've been through the court ringer.
If I can also spin off on that point, Another reason that the mandator may feel inclined to name more than one of their children is, to avoid a situation where one or more of the children feel left out. And instead of naming them as the potential, as additional mandataries who have to make decisions in concert or by majority, the best way to allay their concerns is by imposing accounting obligations. So let's make the process as transparent as possible. So if brother one is responsible and he's the mandatory and administering the assets, then he should be rendering an account on an annual basis or every 18 months, etc., that the other two siblings can review and feel comforted that everything is being managed correctly. And it's not because the mandate or the parent doesn't feel as though that sibling will do a good job or can be trusted, but simply to avoid any discord among the children after they have lost capacity.
Thanks, Yoni and Eric, for those insights. It seems like many things in this line of work, it's best dealt with at the forefront before it ultimately gets to a point where the court needs to get involved or litigation needs to occur. But as we all understand, that's not always foreseeable and not always possible. So we thank you for your comments. I just want to move on now. Maybe Justin, if you could take us to slide 9. We've received a few questions from the audience regarding, when exactly this power of attorney is going to take effect and under what circumstances. And like we've already discussed previously, there are 2 types of powers of attorney that we often consider, these powers that are granted prior to the donor or the person granting the power losing capacity, and then powers which are given to somebody or come into effect after somebody loses capacity. And those are pretty interesting ones in many ways. So Elise, why don't I ask you this? With respect to those different types of powers of attorney, do they differ in how and when they take effect? And if they do, maybe you could give us a little bit of insight on how.
So this is an interesting area because, as I understand, as Yoni will go into, it does differ by jurisdiction. But under the common law, generally it really does, again, like I've been harping on this entire time, depend on the document itself. So if the power of attorney document doesn't have any what we call springing powers, presumably it will come into effect immediately upon when the people sign the document. And when I refer to a springing power, what I mean by that is that a springing power is one that brings a document into effect upon the meeting of certain conditions. For example, it's common that often a power of attorney document can spring into effect when 2 medical opinions are there that a donor is no longer capable. And this is why it's so important to have the powers really carefully set out in the power of attorney document itself. And this is different than in Quebec, for example, where, as I'm sure Yoni will explain, a court declaration is required. But in the common law, you can really make a power of attorney come into effect immediately, and then it can endure after a person has become incapable or has been determined to be incapable.
Thanks, Elise. Yoni, why don't we go to you to get your insight and experience on how things with respect to the activation of a power of attorney are similar or are different in Quebec, and what considerations are at play in that regard?
Certainly. So as Elise mentioned, in Quebec, the mandate absolutely has to be ratified by the court. We refer to that process as the process of having the mandate homologated. And that can be initiated in one of 2 ways, typically where all of the interested parties appear to be on board and moving in the same direction. It can be done by way of a notary. Of course, if there's conflict, it should be brought directly to the court to be heard. If I hadn't mentioned before, the interested parties who would be called to participate in this process are the mandator, otherwise known as the person concerned, any replacement mandatory who's identified in the mandate, family members or individuals showing a particular interest, so it could be close friends, and the public curator as well. But regardless of whether one proceeds with the notary or by the notarial process or through the courts, there are a few steps that absolutely have to be followed. First of all of the interested parties must be served and given an opportunity to speak and share their observations with the notary and the clerk, because the notary and the clerk are ultimately considering whether or not we have reached the degree of incapacity necessary to initiate or give force to the mandate. The person concerned or the mandator has to be served in person and has to be advised of their right to be represented by counsel. It's not always possible to advise them if they are already quite far gone or already within an institution or a hospital or in a residence, but frequently mom or dad have degenerated to the point they will receive by bailiff a copy of the proceedings. The notary and the clerk of the court must actually meet the mandator in person and note their own observations about the proceedings. So, these are some basic due process rights before we put in force a mandate, which will essentially leave the person concerned without any rights over their own affairs. You're going to give them an opportunity to speak their mind. And finally, any decision that is ultimately made has to be made on the basis of medical reports, a medical assessment by a physician, a geriatrician, or a neurologist, as well as a psychosocial assessment, which is performed by a social worker. So this process, given that this is a seminar on estate litigation, this process is really a flashpoint where many of the disputes arise, and those disputes concern a number of things. First of all, the degree of incapacity, because the mandate is only going to come into effect if the mandator no longer has the capacity under law to manage their affairs. If one of the interested parties, including the person concerned, disputes that the mandator has reached that degree of incapacity, there's going to be a dispute, and it's going to be resolved on the basis of the medical assessment, the psychosocial expertise, and the observations and testimonies brought before the court. Another point of contention may be the suitability or the ability of the mandatory to actually accept the mandate that is given to them. And a third point of contention that leads to litigation can be the validity of the act itself. Was the mandate prepared at a time when the mandator had already lost capacity? If that's the case, then it's not a valid mandate, and it will be contested on that basis. What is important to note is that at the point of homologation before the tribunal, it's either going to be homologated or not. It's not partially homologated, and it's not going to be modified by the court. The court either finds that it's suitable or it isn't. And in cases where we haven't reached, let's say, the threshold of incapacity necessary to homologate the mandate, the court can render any decision necessary to protect the individual, the person concerned, including imposing protective supervision under the public regime.
Thank you, Yoni. And that is interesting. It does seem like a point in the lifespan of the power of attorney, this activation point, whether or not it should be coming into force, is an interesting one. It's nice that in your jurisdiction, at least, the court is always involved. Maybe I'll go to you for a moment, Eric. In your experience in British Columbia, is the activation of the power of attorney upon the incapacity of the donor something that the court has to get involved in, or is that more of a private situation in BC?
Well, in BC, you wouldn't require any form of certification from the court that the person lacks capacity and that therefore the enduring clause of the power of attorney has been triggered. is really a question of whether or not this person has, on a factual analysis, a lack of capacity. So what you could have, for example, Elise mentioned a springing power of attorney, which would, for example, take effect the enduring power of attorney if two doctors certify that the donor has now lost capacity and is incapable of managing their own affairs. You can have various provisions put in place, but there is no requirement for the court to make that determination. In fact, if the court is required to step in, then that would be by way of committeeship application, where you go to court, you would have service on the adult, you would have two medical professionals who would have to swear affidavits that in their opinion, this person now lacks capacity to look after themselves or to manage their affairs. But that would totally override any existing power of attorney anyway. So I think in the common law jurisdictions, it's all pretty much the same. It's a question of, did you put in place springing provisions that have to be met in order for that power of attorney to be triggered? Or is the power of attorney valid immediately and it becomes an enduring power of attorney once the adult loses capacity?
Thank you, Eric. That is some great insight. And I think now this brings us to a nice turning point in our discussion, and a natural one. Justin, if you could please take us to slide 10. So far, we've been discussing the scope of powers granted by a power of attorney instrument, who can receive those powers and how might they be exercised. We've talked a little bit about how and when those powers might take effect. Now I want to turn to and consider what happens when people's plans change, donors' intentions shift, or donees' responsibilities are shunned. Yoni, I'll go to you first with this question. Can a protection mandate be revoked by the mandator? And if so, what's that process look like?
So Eric touched upon this earlier in our discussion, and it holds true in Quebec as well. A mandator can really only revoke a mandate if they have the capacity to do so. It's the same capacity to grant a mandate. So if they're lacking that capacity, that revocation can't occur. The Civil Code nevertheless envisions a scenario where the mandator regains capacity and can then apply to the court to have their capacity recognized and subsequently revoke a mandate. Those are not common occurrences, but you can imagine a scenario where someone has been hospitalized, they have slipped into a coma for an extensive period of time. And during that period of time where they're incapacitated, the mandatory named in their mandate has taken on the process of homologating it and begun to act. And as soon as that person comes out of their coma and regains their capacity, they may themselves apply to the court. The institution in which they're being cared for can advise the court and apply to have the capacity determined or reinstated, and even the mandatory themselves can do so. Again, always on the basis of medical assessments and psychosocial reports confirming that the person concerned, has regained their capacity.
Thank you, Yoni. And Elise, let's hear from you for a moment. We've just heard from Yoni that in Quebec, there is a mechanism by which people concerned, including the mandator, can bring an application for an order to have their capacity reinstated. Is the process similar in British Columbia?
So every jurisdiction is slightly different and has its own law and legislation with respect to how powers of attorney are revoked. In British Columbia, there is a process for how to remove an attorney, so long as the adult is not incapable of understanding the nature and their consequences of doing so. So in British Columbia, you have to give written notice of a revocation of a power of attorney, and that change must also be signed by the adult. And the change is not effective until the notice is given. Practically, this raises a question of, in certain circumstances, if a donor hasn't told an attorney that they've appointed them. So for example, if you execute a power of attorney document, go through some thinking, change your mind, and decide to revoke it, but you had never actually told the attorney that you were appointing them. This creates a bit of a dilemma as to whether or not you have to give them written notice of something they were maybe not necessarily aware of in the first place. It's also been argued that when a donor makes a new power of attorney that contains terms that are inconsistent with the previous power of attorney, the effect is to revoke that prior power of attorney, even if there is actually no express language of doing such. And in those cases, the court will actually have to determine whether or not the two power of attorney documents can coexist, or whether the more recent power of attorney document implies that the prior one has actually been revoked.
Thanks, Elise. That's interesting. And now I want to consider the flip side of that scenario, where maybe it's not the donor or the mandator who wants to revoke the power of attorney already granted, or they're not claiming that they've regained capacity, but it's the attorney themselves or the mandatee themselves that no longer wants to act and wishes to renounce their appointment. Eric, maybe I can go to you on this. Are attorneys under a power of attorney at liberty to give up their responsibilities at their discretion? And if they do, where would that leave the donor?
Well, because essentially you're acting as an agent, you can't be forced to continue with that role. So you should be able to resign or step down as an attorney. The simple answer to what happens then is, well, what does the power of attorney say as far as alternates is concerned? Is there a provision for an alternate attorney that in the event that I am unable, incapable, or no longer in a position to act or willing to act as your attorney, who then is the next in line to act as attorney? Because if there is no alternate, then by resigning or by essentially stepping down as the attorney, you're putting the adult in a position where there is nobody to manage their affairs, which in British Columbia at least would require a committeeship application to court for the court to appoint a court-designated person to act on that person's behalf. But yeah, you cannot be forced to act as an attorney for another person.
Thanks, Eric. Yoni, let's hear from you on the same point. Is the experience similar in Quebec?
So yeah, the general principle is the same. The attorney is permitted to resign or renounce their appointment, but the law stipulates that they must first arrange for their replacement to take act of their responsibilities, or to apply to the court for protective supervision if as Eric said, the power of attorney doesn't provide for an alternate. The code also states, and this is where the mandatory has to be careful, that the mandatory can incur liability if they decide to resign at an inopportune moment. So one can imagine a scenario where there's an anticipated transaction on the sale of some property, could be the mandator's house, and the mandatory is the person who's supposed to sign in the transaction, and decides that they've had enough for whatever reason it may be. They renounce at prior to the transaction closing. They jeopardize the transaction, and maybe the deal doesn't go through, and the mandator is subsequently pursued by the prospective purchaser. So the mandatory, in having acted hastily and without ensuring that someone has replaced them in order to take over for the transaction, could incur personal liability in that case.
And I think you could probably make that argument in common law jurisdictions as well, that you can't leave the adult in the lurch. Because remember, once they've lost capacity, you have to act in their best interests. You're a fiduciary. So if you just decide to essentially torpedo a deal by stepping down as an attorney, and that is going to jeopardize the deal, then the question would be whether or not that was a breach of your fiduciary duty, whether or not there are damages that are arising from that step. But generally speaking, you are able to resign or renounce the attorneyship at your choosing.
Thanks, Eric and Yoni, for your insights. That makes good sense to me. You're not obligated to see this thing through to the very end, but as we've discussed, the power of attorney is a significant responsibility and one that can't be effortlessly shirked in all circumstances and may even result in liability if the mandator or the donor is left in a lurch. Justin, if I may ask that you take us to the next slide. I have myself thinking, for all this trouble, is a person who's receiving a power of attorney entitled to be compensated for their efforts in taking care of the donor or the mandator throughout their incapacity? Elise, let's go to you on this one first.
So there's a general common law presumption that someone who is in the position of a fiduciary cannot make any compensation from their role as a fiduciary. So as such, that would apply for an attorney. And generally, an attorney is not entitled to remuneration. However, this is not necessarily the case where the remuneration is provided for contractually in the power of attorney document. So in British Columbia, this is also governed by the Power of Attorney Act, which prohibits compensation for an attorney unless the document authorizes the compensation. And then the Act also sets out the amount or the rate. Section 24 of the Act also permits an attorney to be reimbursed for reasonable expenses when the power of attorney document specifies for attorney remuneration. This is a really interesting contrast between that common law principle that I referred to earlier, which says you can't make compensation from your role as a fiduciary.
Thank you, Elise. So it does appear that there is some latitude for compensation in some circumstances, but it is by no means absolute and maybe in some cases even prohibited, depending on the instrument. Yoni, what about in Quebec? Is the assimilation vis-a-vis compensation similar?
So the rule is that remuneration is entirely up to the mandator and is provided in the document in the power of attorney itself. However, the case law has come to nuance that notion. The remuneration, nevertheless, should be proportional to the amount of the assets that are being administered or the value of the estate of the individual. So, and therefore may have to be adjusted throughout the course of the mandate if perhaps, the person concerned as they get older lives out quite a bit longer than they had anticipated and budgeted for, and there's less money to care for their needs and also pay the mandatory. But generally speaking, the mandator is allowed to provide for the remuneration.
That's interesting, a little bit of an interesting difference as across jurisdictions. We also have a question here, and it's an interesting situation I think that we see sometimes crop up often, where we have a donor who has become incapacitated and they've appointed someone before their incapacity to be their attorney. And this person's often a close family member or someone dear to them. And in many cases, prior to losing incapacity, the donor has been supporting that person financially prior to that appointment. Suppose that the instrument itself doesn't necessarily provide that this person is entitled to compensation. Is there anything at the common law or in statute that would allow these kind of ordinary course payments or these support payments that have been made prior to the person losing capacity to continue, even if it's not expressly provided for under the instrument? Maybe, Elise, I can hear from you on this, and then we'll see if Eric has anything to add.
Yeah, so as you can imagine, this can arise in situations where kids are taking care of their parents, and then that same child has been deemed to be the parent's attorney. And as I said earlier, the fundamental proposition at law, at least in British Columbia, states that an attorney cannot get paid for their role, which is stated again in the Power of Attorney Act. So support provisions really should be provided for in the Power of Attorney document. Otherwise, they are contrary to those principles. Attorneys may often think that they are actually entitled to payment, but it's really not true. And in BC, the law is actually quite stringent on how that payment structure should be set up. But perhaps Eric can give a bit more insight into this area as well.
Yeah, I mean, the basic rule that is that you cannot self-deal. You automatically be in a conflict of interest if you're paying yourself support payments, right? So in order to avoid that in any way, the the donor would have to choose a different attorney or would have to delineate and set out specific payments that are authorized to be made under the power of attorney. I think one point that we haven't mentioned and which is important is that when your dad or mom or whoever asks you to be a power of attorney, at least under common law jurisdictions, you have to realize the immensity of the role that you are taking on, because once they lose capacity, as I've mentioned, you're in a fiduciary role. You have obligations that go way beyond what you would have prior to the lack of capacity. And it may involve a lot of work. It may involve a lot of time. And if you're not aware of the fact that you're not going to be able to claim compensation, it may not be something that you want to take on because there's also risk. You could get sued. And so it's really important that when you are picking someone, that person be educated on the role of the attorney, what they can and cannot do, and the fact that they're in all likelihood not going to be compensated for their efforts.
That's interesting. Eric, thank you. And I think it leads nicely into our next group of questions, which relate to the ability of third parties, executors of the donor's will, or anybody else to get some insight into exactly what an attorney or a mandatory is doing with their power throughout the time that it is in effect. So Justin, maybe you could take us to slide 12. And the question that we have here is, does the attorney have the duty or any duty to inform the donor of the actions that they're taking pursuant to their power, or do they have any reporting obligations otherwise to anyone? Elise, maybe I can hear from you first on this point.
Yeah, so the obligations of a power of attorney to account do differ slightly from those obligations of an executor or a trustee. And in British Columbia, these obligations are actually included in the Power of Attorney Act regulations. And an attorney acting under an enduring power of attorney must keep the following records in relation to the period of which they are acting as an attorney. So they have to keep a list of all the adults' properties, liability, and including an estimate of their value. And they also have to keep accounts and other records respecting the exercise of the attorney's authority, and keep all invoices, bank statements, and other records necessary to create a full accounts. And so while there is no, the obligation I can say isn't as sort of formal as it would be for an executor, in the sense that the attorney doesn't have to go formally past their accounts. An attorney should always count to his or her donor when that donor is capable. Obviously, when a donor becomes no longer capable, the attorney also has to account to the donor, because at the end of the day, the power of attorney arrangement really is one of an agency agreement. And with enduring powers of attorneys, those attorneys are also acting as fiduciaries. And in British Columbia, it's actually interesting. Once the donor becomes incapable, there is no obligation to account to the public guardian and trustee. And so that's sort of an interesting distinction. But perhaps Yoni can give some insight into Quebec.
Yeah, that is interesting. It is a private instrument after all, so it makes some sense that there isn't a reporting obligation to the public guardian and trustee in all cases. But what about in Quebec, Yoni? Similar reporting obligations? No reporting obligations? What's going on out east?
Okay, so before getting into what's happening out east, it may be a good moment or opportunity to plug the next installment of this seminar. So our colleagues will be speaking in greater detail in the upcoming seminar on the duty to account and the rendering of account. So take this as sort of a high-level review of what's going on in Quebec. Under the current rules, in the absence of any specific obligation to account within the Act itself, there is only an obligation to render an account upon the termination of the mandate. And I had mentioned earlier that termination occurs upon death, Termination can occur upon resignation, and termination can also occur upon judicial revocation. So not simply the revocation by the mandator himself or herself, but also where third parties have applied to the court to have the mandatory removed for having committed some serious fault, such as misappropriation of funds or gross neglect of the mandator. When the mandate terminates upon the death of the mandator, the mandatory renders account to the estate, or really to the executor or the liquidator of the estate. When it terminates upon resignation, the mandatory will render account either to his replacement or to whoever assumes the obligation or the responsibilities under protective supervision, if it's the curator, a tutor, or the public curator. And that will be similar for termination upon judicial revocation. The mandatory will be obligated to render an account to whomever takes on the charge following.
That's interesting, Yoni. I think, and begs the follow-up question. Maybe I can just pose it to you briefly. You mentioned earlier when we were discussing one of the other topics that it was a flashpoint for litigation issues to arise. In your experience at this time, when the account needs to be rendered, do you ever encounter any litigation issues when people finally get a sense of what's going on?
Oh, well, absolutely. And again, I think that our colleagues are going to speak to that in greater detail next time. But there's, when reviewing the account and seeing what has occurred, there are multiple areas or multiple reasons where someone might object to the administration of the assets by the outgoing mandatory. Accounting's done. Experts are called upon to review, and it's lots of opportunities, unfortunately, for a dispute. What I didn't mention, and what I hoped I had the time to do so, is to discuss what is provided for under the new legislation, the amendments under Bill 18. And again, I had mentioned that one of the intentions of the legislator in enacting this bill is to add certain safeguards to prevent exploitation or abuse of the mandator. So under the new provisions, which will be coming into force in June 2022, the mandator in preparing his act and preparing the mandate is to appoint a third person to whom his mandatory must render account. And the new bill also provides that rendering of account has to happen at least once every 3 years. So naturally, we recommend that occur more frequently because 3 years, much can be done in that period of time. But certainly, this is a measure that will go a long way to protect the mandator, and also, as I had alluded to earlier, comfort the other children, the other relatives, the friends, people who are concerned about the mandator and want to ensure that everything is being dealt with correctly and appropriately.
And I agree with you, Yoni. That does sound like a positive change in the law that would be good for all parties involved. Justin, if you'd be so kind, maybe just take us to the next slide. I want to quickly address some questions that we've received prior to the presentation regarding third-party considerations from the perspective of people who may not be the donor or the donee, but persons acting or interacting with them. Suppose you're trying to buy property from somebody purporting to act under a power of attorney, or you may be wanting to lend money to somebody purporting to act under a power of attorney. The question we have is, are third parties in all cases required to act on a purported power of attorney? If they are, how is that enforced? And if they're not, what recourse does the attorney have to have their authority recognized so that they may act in the best interests of the donor? Maybe Elise, I'll go to you first on this one.
So perhaps some of the most frustrating restrictions on the power of attorney come from those dealings with third parties. At common law, third parties can't be compelled to deal with agents. And as most estate planners will know, this problem manifests itself most commonly with financial institutions who are likely to require formal power of attorney documents and often further valid evidence of authority. For example, if you give a power of attorney document to a bank, the bank is not necessarily required to acknowledge it. And a bank may not want to comply with that power of attorney document if it's aware of ongoing family disputes. The solution here might be to go and get a court order forcing the bank to comply. But generally, the third party doesn't have an obligation to look beyond the power of attorney instrument itself, so long as it complies with the legislative requirements. If there are concerns, the safest thing for the third party to do would be to go and get legal advice. Or, as I said, if the third party is aware of ongoing legal disputes or ongoing disputes amongst the family, it can require a court order.
Thank you, Elise. That is an interesting situation. No obligation for the third party to look beyond the document, and as it seems, no real obligation to act on a purported power of attorney without the authorization of a court order. Maybe I'll go to you, Eric, and ask you this. If you are a third party and you do choose to do some dealings with a person acting under the purported power of attorney, are you exposing yourself to any liability if you don't look beyond the face of that instrument or whatever it may be and choose to act without a court order in front of you?
Well, I mean, it really depends on what due diligence you did to try and determine whether or not this person has proper authority. If you're aware of there being disputes or there's an issue relating to undue influence under which the power of attorney was obtained, or there's an ongoing saga relating to the validity of the POA, then you should always exercise caution and say, well, I'm not prepared to deal with you unless there's a court that says that this is a valid instrument, or there's a comiteeship or a guardianship order which usurps it. But generally speaking, you are entitled to, when you're presented with a document which at face value appears to be valid, and you're acting bona fide and you have no reason to suspect that there is anything going on, you ought to be entitled to rely on that unless your reliance was unreasonable and you should have known better, which again goes to the due diligence that you have.
That makes sense to me, Eric. Thank you. And it maybe that explains some of the reluctance some third parties may have to act on a purported power of attorney without a court order, because seemingly there is an obligation, at least to some extent, to do some diligence before you do that. What about in Quebec, Yoni? Maybe we get your quick comments on this point.
Sure. Very quickly, I suppose one of the greatest benefits of having to proceed by court ratification or homologation is that it can be easily verified by anyone that they are dealing with the person, the mandatory with the authority to actually transact. And so, in other words, third parties have a basic obligation to do some very basic verification. You could check the court docket. You can request a certified copy of the judgment that homologates the mandate. One issue of interest is in the event of a dispute over let's say there's a dispute where a party has applied for the judicial revocation of the mandate. In those circumstances, the mandatory will continue to have the authority to act until there is a judgment either revoking the mandate or maintaining the mandate. And that will also appear, in the court docket and through very basic verification of what's happening in the court record.
Thank you, Yoni, for those insights. We just had one question roll in with respect to powers of attorney granted maybe in other jurisdictions. Suppose I grant a power of attorney in Alberta and I own property in British Columbia and I'm authorizing my attorney to act in British Columbia. Are third parties who would be dealing with my power of attorney obligated to act on documents that have been executed in a jurisdiction that is foreign to them? Elise, maybe you could give us some comments on the enforceability of, or the cross-jurisdictional applicability of these types of documents.
So generally, as we've alluded to already, it's up to the third party receiving the power of attorney document whether or not they choose to receive it. However, power of attorney documents often grant attorneys rights with respect to land title or real property. And each land title office will require their own power of attorney for their own jurisdictions. So in British Columbia, you're required to have a power of attorney from British Columbia. In that case, and because of that, it's often more useful to make powers of attorney that comply with each jurisdiction where you have assets. We usually don't recommend that as a third party to accept a power of attorney from another jurisdiction, especially when the donor you're receiving the power of attorney from is incapable and you can't necessarily confirm this with them or the client.
Thanks, Elise. And I think, Justin, if you just take us to our Q&A slide, I have one brief question here that I maybe just want to check off the list for our viewers here. Eric, and I'll go back to you on this. We spoke earlier about the significant responsibility an attorney has under one of these mandates. We have a viewer asking, because of the significant responsibility and potential liability that an attorney may face in carrying out their role, is liability insurance available to them or something that can be purchased?
And that's a good question. I don't know whether or not there are insurance policies, I don't know off the top of my head, that would cover a power of attorney for their acts as attorneys. But I think you'd have to then, even if they were available, look at who would be paying for that policy. If it's not provided for in the POA that this person can insure themselves, and I think they'd have to pay it out of their own pocket. And I don't know whether or not that would count as a reimbursable expense. Because the argument could be that it's for their own benefit and not for the benefit of the adult. But I'd have to consider that a little more carefully. I'm not aware of anybody that acts as an attorney having liability insurance for that.
Thank you, Eric. And that's interesting. And everybody, I am mindful of the time, and I see that we're at 11:31 Mountain Time here. So I just want to take the opportunity to thank everybody for being here with us today, and for everybody who has submitted questions. A special thanks to you. You've made this a great session for everybody. And upon the conclusion of the presentation, I'll remind the viewers, you will have a link in front of you, which you can click and give feedback to me and to our presenters. So we would all appreciate if you would utilize that. Your feedback is always appreciated, so we can continue to tailor these seminars and these webinars to your interests and to your needs. And I'll just say that if anybody has posted a question in the chat that we didn't get to, or that didn't get addressed fully, or you didn't get the answer that you were exactly looking for, don't hesitate to reach out to me, to any of the panelists, or to anybody at our firm. We'd be happy to provide you with further information or to put you in touch with somebody who may be able to assist you. Yoni, Elise, Eric, thank you for your time this morning. It's been a pleasure.